Hello, I see everyone joining in here. I'm going to give a couple minutes for people to get settled in. Let's see if we can get a little feedback. There we go. So welcome everyone. This is the first student loan and bankruptcy symposium session. This is the first time we are actually hosting this, and with a recent partnership that we're doing as well. So my name is Mandy Ballinger. Vice President of NextChapter, and joined Joshua Cohen, and he is with Student Loan Toolbox. So today, Josh is going to be presenting, and as I mentioned, this is the first of 5 sessions. So thanks for joining today. We're going to be going over student loan basics today, and we have a couple other sessions that we're going to send links to. If you didn't register for, please feel free to check those out as well. So today's session specifically is going to be about student loan basics. So the symposium is covering really a lot about bankruptcy and student loans, where they overlap. And we find at NextChapter, we have a lot of questions from bankruptcy attorneys that are looking for, different ways that they can help their clients, including relief within their student loans. And this is a very big topic right now. As we know, the Supreme Court is discussing the situation now with the student loan forgiveness and what's going to happen with that. But as you're going to hear from Joshua for the next couple of days, that there's a lot of other options as well for consumers who seek relief in their student loans. So with that, today we're going to talk about really the alphabet soup of student loans. So the acronyms, what they mean for your clients, be discussing things like payment plans, issues with default, and then just kind of a quick overview of the landscape as well. This is going to be presented by Josh Cohen. He is the student loan lawyer. He's been practicing law since 2008, defending and assisting consumers and with student loans. So as the preeminent expert on this topic, Josh has been on Fox and Bloomberg, as well as quoted in multiple articles. So I'm going to over here to Josh, and I'll let everyone know too, just as a housekeeping, if you want to put any questions you have into the Q&A, we'll answer those as well. And I'm going to make sure that everybody's muted, and then we'll get started here. Okay, Josh, I'll let you go ahead and take over.
All right, folks. Hello, my name is Joshua Cohen. I am the student loan lawyer. I've been doing this since 2008, the student loan portion. And a little while ago, my brother and I created Student Loan Toolbox, which is not just the workshop that I teach, a 2-day intensive workshop, which is CLE credit in most states. But we also have software that helps folks put together their student loan stuff, because over the years, I've worked with many bankruptcy attorneys and they've got software to help their stuff. So why not do something that helps your student loans? And so we got together with NextChapter because bankruptcy and student loans, they're just kind of good bedfellows. The first place a student loan client goes is to a bankruptcy attorney, because that's where they go when they have any kind of debt problem. So let's talk about student loans. This next hour or so, a little less, we're going to be doing just the student loan basics, as Mandy said. My ground rule for questions, you've got the Q&A box, so just throw your questions in there whenever you have them. If it's relevant at the time of what I'm doing, I'm happy to have someone break in and ask that question. If it's coming later, I'll hold them off, but please feel free to ask your questions. Student loans is a very sticky, tangly spider web, and we've got to get those anchor points done first before we get into it. And since I've only got about 55 minutes or so, I'm certainly not going to get too deep, and I don't want to scare you either. So with that, let's jump right into it. Our topics for this hour, we've got federal versus private student loans. Who are the entities involved that are scaring your clients? We'll talk about details, the types of federal loans and the repayment plans. Forgiveness, yes, Virginia, there is forgiveness, it does exist. Talk about default and a very quick overview of why making your federal loan a private loan is a bad idea. So with that, let's just jump into types of loans, okay? So we start with a federal loan. It's a loan that's guaranteed or insured or funded by the US Department of Education versus a private loan where the government is not involved at all. And then we have state loans. These are loans offered by a state agency. They're available to state residents or non-residents that attend school within the state. So I use New Jersey as an example. New Jersey has what's called a New Jersey class loan. It's available to any New Jersey resident, no matter where they go to school, or any non-resident that is attending school in Jersey. So if someone from California goes to Rutgers, they can apply for a New Jersey class loan. If someone from New Jersey goes to UVM, University of Vermont, they can get a New Jersey class loan. So as long as they're New Jersey is the nexus. Not every state has these. California, as an example, actually got rid of their loan program, and they only give grants because they realize the cost to administer it and attempt to get the money back cut into the margin that it wasn't worth it. So they have grants. And they have no administration to have to collect them back. So that was a decision California made. Every state's different, and they are collected by different entities. Colorado, as an example, if you don't pay your Colorado loan, you get sued by the Colorado Attorney General. Is the debt owed to a school or institution ever treated as a student loan? You know, that's a great question. Hold on to that question. I'm going to get back to that. So hold that, please. Okay. So a private student loan, again, is not guaranteed by the US Department of Education. Many of them are insured. There's few, if any, payment options. It's usually pay or don't pay. That's not really an option for your clients. That's determined by their wallet. Enforcement on a private loan is the same as any other consumer debt. The consumer needs to be sued before anything can happen. There's no special rights to collect that a private loan has that other consumer products don't. They are not federal students. They don't have the same power. All right, so let's switch over to federal student loans, and that's what the bulk of this hour is going to be. So who are the parties? Who are the people that we need to worry about? We have the US Department of Education. For our purpose, they lend money and they insure loans that are given by others with a guarantor support. And then we have guarantors or guarantee agencies. Before July 1st, 2010, they lent money. They also insured loans that were originated by private banks. They now service loans held by the Department of Education, some of them. Some examples that you may have heard of: ECMC, Education Credit Management Corp. If you've ever filed a bankruptcy with the federal student loan, you've probably run into ECMC. PIA, Pennsylvania Higher Ed, many folks have heard of them. Great Lakes is another guarantee agency. Most guarantee agencies were created by state legislation, and most of those have gone the way of the dodo because they haven't had any new business since 2010, or 13 years. They haven't really had anything else to do. ECMC and Great Lakes are actually exception to that. Neither one of these are legislative entities. PIA, however, is Pennsylvania Higher Ed, was created by Pennsylvania legislature. VSAC is Vermont Student Assistance Corp. They were created by Vermont legislature. Cornerstone is in Utah, created by Utah legislature. So not all of those are around anymore. If you ever just do a quick Google search for your state and guarantee agency, you may find they don't exist anymore. And as a result, ECMC now is the guarantee agency for many loans that were held by defunct guarantee agencies. So one little puzzle. You have private banks. They are no longer part of the federal loan system. They lent money before July 1st, 2010. They don't anymore. They're not allowed to. However, these loans do still exist. And I'll talk about those in just a minute. Some examples: Sallie Mae, you've heard of Sallie Mae before. Wells Fargo. Navient is not here because Navient never actually lent money as a federal lender because Navient didn't exist until 2014 after that program was terminated. But Sallie Mae lent, again, Wells Fargo, Bank of America, Chase, First Union, MBNA, any credit union you can think of, any local bank you can think of. Almost any bank that ever existed before 2010 was involved in federal loans. It was guaranteed money. There was no reason not. And then we have servicers. They send statements and accept payments. This is much like the mortgage industry, okay, where the servicer on a mortgage doesn't hold the note. They are just there to send statements and to accept payments. They only work on loans in good standing or delinquent, which is a federal term of art. So they will also offer payment plans, they'll offer forbearances and deferments. That's a servicer. Compare that to a debt collector. They only work on loans in default. They contact the borrower to secure payment. Not telling you how good or bad of a job they do. No debt collector is a servicer, and no servicer is a debt collector. So, as experienced bankruptcy attorneys, you have experience with debt collectors such as GC Services or Williams and Fudge or Allied Interstate. Those are all collectors. If you have a debtor that's getting letters from them, their loan is in default. They only get the loan when it's in default. So if they say, oh, no, I haven't defaulted yet. Okay, they're not just in default, they're in denial. As opposed to the servicers like Great Lakes or Nelnet. They don't work on defaulted loans. So if it's still with Great Lakes or Nelnet, the loan has not yet defaulted. It might be behind, it might be delinquent, but it's not in default. Okay. So those are your parts. So now let's get into nitty gritty. This is the most technical slide that we have for the hour. There are two programs. I want you to think of this like Chrysler, Plymouth, Dodge. I probably dated myself with that example, but okay, you've got Dodge, which is the red emblem, and Chrysler, which is the blue emblem. Sorry, Plymouth is the blue emblem, and they're both under Chrysler. And I don't know the last time I saw a Plymouth blue dealership. That's much like the Federal Family Education Loan Program, or FFEL. Okay, this is governed by 34 CFR section 682. In this section, under this program, the loan was originated by a bank or a guarantee agency. The bank is insured by the guarantee agency, that's what exists. The guarantee agency is insured by the Department of Ed. If the loan defaults, the note transfers from the bank to the guarantee agency. The guarantee agency actually has all of the remedies available that you might be familiar with. That Ed can do. If the guarantee agency grows weary, they can file a claim. They transfer the note to the Department of Education, and Ed is now the holder. But it is still an FFEL loan. This is important for some tweaks. Okay, so again, FFEL means it was originated by a bank or a guarantee. This program was discontinued as of July 2010. You cannot get an FFEL loan after July of 2010. Compare that to the William D. Ford Federal Direct Loan Program, otherwise known as DL or direct loans. You borrow directly from the government, from the Department of Ed, 34 CFR 685. Again, the originator is Department of Ed. There is no middleman. There might be a servicer, there might be a collector, but that note is always held by the Department of Ed. Federal loans are not sold, ever. Okay. This is the only option as of July 2010. It started in July of 1993, so here's a very good nugget for you. Anyone that has a loan before 1993, it's got to be an FFEL. Anyone has a loan originated after July 2010 has to be a direct. You do, of course, have the gray area between 93 and 210. FFEL, be direct. Maybe they've consolidated and gone back and forth. Could be either one. But direct loans is the only game in town. None of this applies to Perkins loans. We'll get details on these in just a second. So again, you have FFEL or direct. The only key difference that we care about is who originated the note. It's not about who holds it now, it's who originated. Okay. So again, direct loan is borrowed directly from U.S. Education Department. FFEL is borrowed from the bank or credit union or guarantee agencies. So sometimes they've been calling them commercial loans, which is very confusing to people because they hear commercial and think private. No, it's still a federal loan. Perkins loans are borrowed from the college directly. They're administered by the college directly. Okay, so Perkins is its own little beast. If you're not sure, you have your client go to studentaid.gov, not you. due to the STOP Act, you are not authorized to sign in on behalf of your client, even if you have a power of attorney. The client is in the office with you, then yes, you can do it. If you do virtual meetings and do a screen share, fine, you can do that. But you are not allowed to go in if you are a for-profit attorney. If you're a nonprofit, legal aid, or anything like that, yeah, you're allowed to do it. The STOP Act was created pretty much to stop scam artists, but they put lawyers in there so that the scam artists don't partner with the attorney. Department of Ed is working on a third-party system that will allow us to get in, but that is far from being a reality. So your client goes to studentaid.gov, they get the information, and it will clearly say direct loan, FFEL, Perkins, whatever. All right. Just a quick myth for you. Navient has left the federal loan system. True or false? False. Navient no longer services direct loans, but they do own and service FFEL loans tied to Sallie Mae normally. Navient is an offshoot of Sallie Mae. So many Sallie Mae loans were transferred to Navient, or Sallie Mae may still own it, but Navient is the service. So don't assume when you see Navient, oh, it's a private loan. That's incorrect. It can be an FFEL. Again, go to studentaid.gov. Only federal loans are there. If you see a Navient loan there, it's an FFEL. So if your client says, no, it's private, no, it's federal. Look at the studentaid.gov report. If it's not there, that is a 99% chance that it is not a federal loan. Of course, it's not foolproof, but I do find that student aid data is about 99% accurate. All right. So the three big loans to talk about on the federal side, we have Stafford loans, which come in subsidized and unsubsidized. What's the difference? Subsidized is need-based. The school is the one that determines the need. It's a proprietary formula. We never know. Unsubsidized is not need-based. Almost every undergrad who's gotten one, if you went to law school, you probably got an unsubsidized Stafford loan. If you go to any graduate level, you will get unsubsidized. Subsidized means the government pays interest during deferment. So the 4 years that we were in undergrad, Congress paid the interest on our subsidized. I don't think Congress realizes they're doing this because they keep raising the interest. In any case, that's the difference between subsidized and interest. Only deferments is when they pay. Forbearance, you're on the phone. Then we have plus loans. Credit does matter loosely on a plus loan. They're easier to get than a Capital One card. They just want to know someone has the ability to pay. There are parent plus loans and graduate plus loans. Graduate plus loans are for graduate students. Parent plus loans are for the parents of an undergraduate. So here's another nugget for you. A parent plus loan is in the name of the parent. It can never be transferred to the student. The student is never liable for the loan. So if you got a parent that says, yeah, I want to transfer this to my kid, no. Unless the kid goes out and gets some kind of private loan or a HELOC or something else, that plus loan never transfers to the kid. So the parent's always liable. Now, a plus loan might require a cosign or an endorsement. The child, the student, can never be a cosigner on a parent plus loan. So if you have someone that comes into your office and says, yes, my child and I are on the loan together, it is not a parent plus loan. If it was for undergraduate, and we know it's not a parent plus loan, guess what it is? It's a private loan. The only way the student and parent can be on the loan together is either a private loan or a graduate plus loan, because as a graduate, parent can be on it. But a graduate plus loan is for the student, and the parent might be the endorser or co-signers on plus loans are very easy to get rid of. If you do a consolidation, the co-signer doesn't go with it. So boom, done. I'm not worried about co-signing. The amount is based on the school's budget. or the cost of attendance. Now, cost of attendance is tuition, room and board, whether you're on or off campus. So rentals and food, textbooks, other indirect costs or lab fees, cost of a new computer, because every time we start a new program, we buy a new computer. It includes travel to and from campus, whether you are a commuter student or even if you live on campus, but maybe you're a student in Ohio, but you live in California. Well, then you got to pay for the plane ticket to get you back and forth for your breaks. So all that travel. It covers study abroad. It also covers dependent care. You're an older student and you have dependent care needs. It can cover that. And it can also cover costs for ADA compliance or disability and things of that sort. This is why when the biggest mistake bankruptcy attorneys make is they say, oh, well, this loan was more than tuition, so it's dischargeable. That's absolutely incorrect. That standard for non-dischargeability or dischargeability, with getting off topic under 523A8, it is based on the cost of attendance, the school's budget for the year, not tuition. All right, and which is why plus loans are easily, they can easily be 10 to 30,000 a year, which means over 4 years, you're talking 40 to 120,000 per child for that parent. And again, that loan never gets converted over to the kid as a parent plus loan. And then we have Perkins loans. Again, they're originated by the school, they're paid to the school, they're collected by the school, they're with the school. If the school loses their Perkins program, then the entire program is assigned over to the Department of Ed, not just one student, the entire school program. Now, this is a good place to answer that question. Is a debt owed to a school or institution ever treated as a student loan? It's only treated as a student loan if it is a student loan. Okay, a Perkins loan is a debt owed to the school, but it is a Perkins loan. It is a student loan. It is non-dischargeable because it is a federal loan. It's federal because the money is actually from the government paid to the school for the school to dole out. So it's a federal loan. If it's not a Perkins loan, then you have to investigate. Are they collecting tuition or are they collecting some kind of legitimate loan? This is a good question. A loan for dischargeability issue, the question of dischargeable or not dischargeable, was the loan originated at the time that the student attended the school, or was it tuition that is owed and the kid graduated or dropped out, whatever, and it's been 5 years and the school says, hey, you still owe this money. Do you mind signing this promise that you'll pay it back? Signing that promise is a contract, but it's not a promissory note. It's not a loan. And that tuition isn't converted to a non-dischargeable student loan debt. There are case law out there. Okay, it's got to have been a loan at the time of attending the school, at the time the bill came due, and there needs to be a transfer of money. It's not just a transfer on the books. Okay, can a Perkins be consolidated and discharged? Consolidated, yes. Discharged, no. Consolidating a loan doesn't suddenly strip it of student loan characteristics. So if it is a federal student loan, it's a student loan, and consolidating it doesn't strip it of its student loan quality. It is still non-dischargeable. Okay, because again, it's not the fact that it came from the school, it's the fact that it's a federal loan. So if you take a Perkins loan and consolidate it with a direct loan and make it a direct consolidation loan, that's still non-dischargeable, the federal loan. Okay, the last loan are consolidation loans, which, great, you just segued me into it. It is similar to a refinance, but the term of art for federal loans, we say consolidation. For private loans, we say refinance. A consolidation pays off the underlying loans. You have a brand new loan. Credit is irrelevant. You are allowed to have a consolidation loan if you want one. Just a quick note, there's something called the spousal consolidation loan. They're available from 98 to 06. This is when married couples were allowed to consolidate their federal student loans together. These are nightmare loans. However, in October, Congress finally got their act together. They created the Split Consolidation Loan Act. President Biden signed it. and we are just waiting for the Department of Ed to release the process. This will allow spousal consolidation loans to be split finally, which means when the couple gets divorced, they can also split their consolidation loan. This was never available before October. We're just waiting for procedure. When that happens, I'll let people know. Okay. Good question. So the starting place again is at studentaid.gov. The client is going to go there. They're going to sign in. They get the data, including the date of origination and the amount of the loan, the current principal and interest, along with the interest rate. Most of the time, they'll have their current payment plan. FFEL doesn't always include it. The current lender, servicer, and guarantee agency. It will not list the debt collector. If it's in default, you contact whoever holds it, whether it's Ed or the guarantee agency, and they're happy to tell you who the collector is. It'll also give you the historical status of the loan, dates they're in repayment, default, forbearance, deferment, whatever. So when your client comes to you and says, I've been paying this for 20 years, you take a look and say, well, you've been in default for 15, which means you've been paying it during default through garnishment. Well, yeah, that counts, right? Yes and no. About administrative discharge, how we get rid of the loans through a paper application. They're either based on the student or the school. The ones based on student, if the borrower dies, yes, the loans go away with them. They do not affect the estate. They literally go with the borrower. If it is a parent plus loan and the student for which they took it out for passes, then the parent is let off of it. There's also a partial discharge for a spousal consolidation. If one of the spouses passed away, their portion of that spousal is discharged. I know all about how the Southern District of New York Student Loan Modification Program works, and they're reacting to it fine. And the reason is Judge Morris, who put together the SDNY program, modeled it after what's going on in Florida. The best place to look, I'm not playing favorites. If you go to the Southern District of Florida bankruptcy website, they have a student loan program. And this is what a lot of programs are modeled after. The Middle District of Florida was the first. Southern District tweaked it. Northern District of Florida now accepted as well. Eastern District of Pennsylvania also has a program. Vermont has a program. The SDNY, what makes it different is nobody else was involved in it. Judge Morris put it together himself. No, being over 65 is not a disability. Nor would I ever say that because I know lots of people are over 65. That will come up in another webinar where we talk about the DOJ discharge. So make sure you signed up for it. These are great questions. All right. Total and permanent disability. If the borrower is a veteran that is 100% disabled from a service-related incident, they can get their loan discharged by filling out an application. If they're on Social Security disability and they have a review period of 5 or more years, as reported on their benefit period query, which you can get from SSA. If it's 5 or more years, you staple that to the application, their loan is going to be. The last one is, if none of these work, a doctor certification, why the borrower can't work. And it's all on one application. The doctor looks at it, it's a bunch of check boxes about their motility and things of that sort, and why they can't work. And their affliction has lasted or will last for 60 months. That's really the guideline and being very both of people. This also applies to mental disability. So a psychiatrist can sign off on this. These are really powerful. These are also great setups for adversary proceedings. If you don't get this, you could walk in. This will help you with the DOJ adversary we're going to talk about in the webinar tomorrow. All right, the school-based one. These are, first of all, a false certification. The school certifies that the borrower, the student, is qualified to be at that school. If the student never graduated high school and never got a GED, then how are they in college? So that's a false certification. Or if they accepted a student that could not meet state minimum job requirements, and thank God, love Florida. The best example is a CDL truck driving school that accepted a blind student. Okay. ID theft or fraud. These are more common than you realize, especially in the age of digital signatures. If the school closed while the borrower is attending or within 6 months of attendance, then they can get their loans forgiven. Unpaid refunds, I wanted to go into because I've never seen one in my 14 years of doing this. And then the biggest one right now, many people are familiar with, is called the defense to repayment or borrower defense to repayment. The Sweet versus Cardona settlement was finally accepted, and people are getting their loans forgiven for going to scam schools or those for-profit schools like ITT Tech or DeVry, Kaplan, or Corinthian, whatever. Borrower defense to repayment is basically stating they committed fraud. The quality wasn't there. I'm not making the money they thought they sold me on. The quality of the education was subpar. I still can't land a job with my graduate degree or whatever it is. And so the Department of Education reviews that, and if they say yes, you were defrauded, then this federal loan is discharged. Field loan subsequently consolidated. Are you asking if they consolidate their FFEL, can they still have defense to repayment? Yes, they can. All right, let's jump into the repayment plans. So we have the 10-year standard plan, which is 10 years, pay off the loan in 10 years. A graduated plan, which is still paid off in 10 years, but starts low and every 2 years steps up. We have the extended 25-year plan if the loan balance is 30,000 or more. And the extended graduated, if your balance is 30,000 or more, you get 25 years to pay it off. It starts low and every 2 years it steps up. That's a great plan. We work for 25 years and get a raise every 2 years, right? No? Okay. If those don't work, we go to the income driven. And these are measured. There are 5 plans out there. The first and oldest is income contingent repayment, ICR. This came out in '93 when direct loans started. It's based on income and the loan balance. It's a 20% formula. This is an important plan. It is the only IDR available for parent plus loans. They can't get a better deal. Then in 2009, we saw income-based repayment come out. This is based only on income and family size. It's a 15% formula, so it's always better than, 99% of the time better than ICR. This is the only plan available for FFEL loans. If you want something better, gotta consolidate. And then there's pay, which is pay as you earn, new IDR, and repay, revised pay. Pay and repay are executive action. They came out from President Obama. In 2012 was pay, and 2015 was repay. They're modeled on new IDR, which is law from 2014. These are the same as IDR. It's based only on income, but it's a 10% formula. So all of these plans are cheaper than IDR. I'm not going to get onto the nuances if you do filing taxes jointly or separately. That can play into it. Also, if you're self-employed versus W-2 employee, there are ways to affect what the payment is going to be. But again, these are all based on income. It is possible to have a negative amortization. What? Negative amortization means the payment is less than your interest. Okay, you might have interest of $100 a month and your payment could be 0. That means your loan is growing. Well, that's insane. But if your loan is growing, how do you ever pay it off? You don't have to worry about it. Just the fourth bullet says the balance of the loan that remains after 20 to 25 years of payments is forgiven. There might be 1099-C issued, potential tax consequences. This is not until 2026. Anything before 2026 is non-taxable because of the American Rescue Act. But the balance is forgiven, so I don't care that the loan balance is good. My Social Security recipient, whose income is next to nothing, they pay $0. It'll be forgiven, or they die. Something will happen. They'll never pay the loan anyway. And then that's it. Social Security, the definition of income is taxable income. So the question back to you, Ed, is the Social Security taxable? Sometimes yes, sometimes no. Depends on taxes. They start by looking at adjusted gross income, but there are other ways to look at other things. So for instance, I'm getting a little off here, but So they like to look at taxes. However, if there's something on the tax that isn't normal income, then I'm going to bypass taxes and use pay stub or something else to show regular income. So if I sold a house last year and I had capital gains, I'm not going to use my taxes because I'm not paying my student loan payment based on my capital gains from selling a house. Or maybe they're a commission one. Well, past performance is not indicative of future earning. So I don't like to use taxes if there's commission. Why did they move from old IBR to new IBR? Because there's a difference in it. And remember, new IBR is not available for FFEL. Old IBR is. Okay. And with IDR, you have to recertify your income every 12 months. Now, we don't have to do that right now because of the CARES Act. I'll get into a little bit of that. Okay. Again, Parent Plus loans can only have ICR, and they can only have it if it's inside a consolidation. Even if they have a direct Parent Plus loan, that's not good enough. They have to take those Parent Plus loans, consolidate them. The direct consolidation loan can have ICR. Okay. And Perkins loans can have any IDR if they're inside a consolidation. And again, I love doing that with Perkins loans anyway, because you take it away from the school, and now it's with all of your other loans. It doesn't affect the payment, because the payment's based on your income. So if I owe 100,000 and I put my 5,000 Perkins loan in there, and I owe now 105,000, the payment is still based only on my income. So I've actually freed up cash flow. I love consolidations with Perkins. All right, so here's just a quick example of IBR payments because they're in the middle. Cheaper than ICR, they're more expensive than ICR. So as an example, if we have a family of two that earn $100,000 combined, if only the husband owes, he owes $960. If only the wife owes, he owes $960. But if they both owe loans, then that $960 is split pro rata between the two of them. They don't double dip. They take their household income, their payment is $960 a month, and it is split proportionally between the two of them based on their benefit. So IBR is a really nice thing. There are other ways to split the spouse's income so that it doesn't count. Again, I don't know if it's this right here is a good cheat sheet. I know that you're going to get a copy of this when we're done. Hold on to this, because this is important. This gives you all the details. So these are all of your plans: ICR, IBR, pay, new IBR, and repay. The term, you get forgiveness after 25 years of ICR or IBR. Pay gets forgiveness after just 20 years. And repay is 20 or 25, look at footnote 1. If you only have undergraduate loans, repay gets forgiveness after 20. If you have any graduate loans, then it's 25 years on you. Why? Because as a graduate student, you make more money. Tell that to the social worker. Okay, the formula, 2015 and 10. Direct loans can have any of these plans. FFEL loans, however, can only have IBR. So here's a reason to consolidate. If you want the cheaper repay, you need to consolidate. Great. What about Parent Plus loans? You can have ICR only, but footnote 2, again, it's got to be inside of the consolidated. Can you ignore the spouse's income? I just mentioned that. Footnote 3. If the borrower is married but files taxes separately, then we can use just the borrower's income. There are other manipulations available. Repay, unfortunately, however, it doesn't matter how you file, they look at both of your income. So, this is your cheat sheet. All right, talk about the CARES Act very quickly. This is still going. This applies only to loans held by the Department of Ed. So it's all direct loans, and some of those default loans from the FFEL or Perkins that have been turned over to the Department of Ed. All right. You are ineligible for CARES Act if you have FFEL loans in good standing. Most defaulted FFEL loans, however, they have added now, it suspends FFEL loans that are in default, no collection. Perkins loans aren't covered by the CARES Act, and no private loan is covered by the CARES Act. If you consolidate, this is a good question, Alec. If you consolidate, yes, you reset the term. So if you have someone that's been on IDR with an FFEL for 10 years and you want to get the cheaper payment and the repay, you are resetting the clock. So they're starting from scratch. So the question is, are they saving enough money that it makes sense? Or should they just stick it out and pay the next 15 years on ID? Good question. All right. What does the CARES Act do? No interest accrues, no payments are required, but you're still getting credit towards income-driven repayment forgiveness. No collection activity. This is good through August 31st of 2023, or 60 days after SCOTUS issues a decision from yesterday's argument about the Biden forgiveness. If SCOTUS gives a decision earlier than June, when they normally do, then it won't be August, it'll be 60 days from when they issue that decision. I don't think they're going to issue it any time before June, so figure until August 31st. This occurred automatically as of April 10th, 2020. No action was required. They have a direct loan, this kicked in. If they have an FFEL in default with Department of Ed, it kicked in. If they have an FFEL scratching their head, calling you, going, why do I have to pay? You're not covered by CARES. All right. IDR recertification. I said every year you have to renew it. You didn't have to do it during the CARES Act. We don't know when recertification will do. Yes, the suspension term did count towards IDR, counted towards repay, even counted towards public service loan forgiveness. Okay, we don't know how they're going to implement the recertification after August. I believe they're going to wait till 2024. They're going to wait at least 12 months. But we don't know how they're going to implement. So stay tuned. Okay. Mr. and Mrs. Anonymous who asked that question, we're not going to answer that question now. You need to come back to the webinar where we talk about the attestation, because you may or may not need to do the consolidation, but we're not answering it here. I don't have to. All right. If you're not in income-driven repayment, do it now, and then that payment is what will roll out come August. If you're on it, but your income has gone down, you can do a recalculation and you'll have a cheaper payment. You have an FFEL, consider consolidated. And then the loan is covered by CARES until August. There's also, this is very important, an IDR account adjustment. Here's my teaser. Please be on the webinar that's coming up later today, where I talk about the account adjustment, because I'm going to get into the nitty-gritty of it. I don't have time here. Okay, but you do want to be there because this is important. Let me tell you, I'm just going to give you the teaser now. I was supposed to get forgiveness in 2034, but because of the account adjustment, I'm going to get it in 2026. I just cut 8 years off of my repayment because of this account adjustment. You can learn how to do it for you and all of your clients. Please be there. They'll post what time that one is. If you haven't registered, go register. All right. So very quickly, public service loan forgiveness. This has been in the news. This is working. You need 3 things: qualifying employer, qualifying loan, qualifying payment. Qualifying employer is any government, a U.S. government, federal, state, local, or a 501c3 nonprofit. Only direct loans qualify. If you have an FFEL, you're not qualifying. And qualifying payments are either the 10-year standard or any income-driven repayment. Okay, you must have all 3 simultaneously for 120 months at any time after October 07. Anything before October 07 doesn't count. But if you've done any nonprofit or government work since October of 07, come to the next webinar on the IDR account adjustment, because there's a way to get retroactive credit if you want to go, or your clients. All right, how do you apply? It's a very simple application. You get your employer or employers to certify that they're a 501c3 or a government and that you were working there. Boom, great. The suspended payments during the CARES Act also count towards PSLF. So if you were working legal aid for the past 3 years, but not making your payments, that's okay. You get credit. All right, let's run through default real quick. Okay, federal loans default after missing 9 months of payment, 270 days. Before that, you're merely delinquent. Compare this to a private loan. You breach the contract after you miss 1 payment, or some promissory notes make a description. Bankruptcy is not a trigger for default. Federal loans don't default because you filed bankruptcy. And I'm noticing now more than ever, even private loans, they're not triggering default because of bankruptcy. An accidental involuntary nonprofit account? No, you must be an official 501c3 from the IRS. That's a great question. I do know law firms that have created themselves as 501c3. I like that, Michael. That's good. All right. Okay, so very quickly, we'll go through consequences. None of these are happening right now because it cares that. There are collection calls. They're allowed to charge up to 25% collection fee or 30 to 40% if it's a perfect thing. Federal tax refunds. They're not doing this right now, but they can offset your federal tax refund. Social Security offset. That includes Social Security disability, but not supplemental Social Security. They've got to leave the client with $750 a month. But they'll take 15% or more, 15% of anything above it. Wage garnishment, no lawsuit required. They give a 30-day warning letter, and then they take 15% of disposable pay after taxes and mandatory health. But then they cut in with the garnishment. This garnishment takes priority over judicial garnishments. It loses child support, but it's priority over judicial garnishment. And they can sue you. I have defended people being sued by the Department of Justice. How do you fix it? You've got three ways. One, you can consolidate. As long as no garnishment or judgment, you can consolidate, again, similar to a mortgage refinance. Because, why did I say that? Oh, because you get a servicer that doesn't hold the note. Credit's not a factor. The process takes 30 to 90 days. You have to do this from one of 4 servicers. I just found out this morning, 2 more servicers dropped out. So there's only 4 servicers to choose from. That's just who's going to bill you. The loan is going to be held by Department of Ed. You can't do this if your only loan is a direct consolidation. So if you have any other loans, then you can do it. You are allowed to consolidate just one loan. If your client only has a Perkins loan, they can consolidate. If they only have one Stafford, they can consolidate. If they only have an FFEL consolidation, they can consolidate. So, good. Or you can do something called rehabilitation. Don't even worry about this because this isn't even going to be available until July of 2024. You'll see why in a second. It takes the word default off a notation. It requires 9 months of payments within 10 months. They get a 15% formula for the repayment, which is similar to income-based repayment. If that's not affordable, you can ask for a financial review, and you can have payments as low as $5 a month. You can only do this once per loan after 2008. Again, if you didn't hear what I just said, it doesn't matter because you're not going to do this until July of 2024. Because until then, we have Fresh Start. That is another webinar that's coming up. I see Kelly put that into the chat box. That's coming up tomorrow. This is an awesome deal. You're out of default in 5 minutes. You pick up the phone, you make a phone call, boom, you're done. Webinars tomorrow. I'll talk about that. Chapter 13 might throw a monkey wrench into it, so I encourage you to be there for it. Okay, very quickly, private loan refinance. I don't know any reason that a federal loan should be refinanced to a private loan. Oh yeah, the advantage is you get a lower interest rate, but what are the cons? Disadvantages, you lose income-driven repayment plans. Remember, private loans is pay or don't pay. Okay, there's limited forbearance. There's no disability discharge, no death discharge. Private loans are allowed to go after your estate. I don't know if they do, but they can. There's no ability to cure the default. There's no forgiveness programs. And a cosigner is often required. So if you can't pay it, your cosigner is going to pay it. Believe me, that's not a place you want to be in. Okay? And I know too many people that file Chapter 13s simply to protect their cosigner. Okay? So I don't know any reason. Yeah, but the lower interest rate, if you're going to get it forgiven, then your interest is moot. It's red herring. Okay, so someone has seen a private loan go after an estate. I'm sorry. Why in the world would you do that when you have a private loan that can, when you have a federal loan that will never go after your estate? Because if you die, there's a discharge. It goes with you. They don't go after the estate on a federal loan. So there's no reason to make it a private. Certainly no reason to refinance it with a HELOC. Oh, please don't. Okay. Here's just a quick list of acronyms. I'm not going to run through them. You can run through them on your own. And then just a very quick list of resources. Again, your client can get all their information about their student loans at studentaid.gov. Student Loan Borrower Assistance. This is NCLC, the National Consumer Law Center in Boston. Great place to go. If you want a manual, more direction and text and case law, they also have a student loan law manual. It's about $110 in a digital book. I don't get any referral fee. You can contact me at my website or my email. Again, I do have a 2-day workshop that I teach every month. And we do have CLE credit for most states, and there's a promo code there. If you sign up for any workshop in 2022, you'll get 20% off. For my software, you can find that at studentloantoolbox.net. And of course, NextChapter Legal for their bankruptcy software. So again, if you have any questions, now's a great time to ask. Anything at all, clarification. Maybe I ran through too fast. I don't know. I'm originally from New York. I talked too fast. I'm sorry.
Okay, perfect. Thank you, Josh. That was awesome. Didn't see any other questions. I'm sure there might be more as we get into the other sessions too. And I think there was a good setup for a lot of the other conversations we'll be having over the next day and a half. So that's awesome. Kelly did share those links. So if you're not registered for the upcoming sessions, I do encourage that you do. And in addition to the promo code that Student Loan Toolbox is offering, we're also offering through NextChapter a free per case filing if you attend the webinar, which you have, or any of the sessions, and if you sign up for our upcoming VK week. So it's going to be a similar format to this. We're going to provide experts to come and discuss all things related to, around, and close to bankruptcy. We did this in 2020. We're looking forward to doing it again this year. The date is to be determined, but we do have a pre-registration link that we just shared. So again, if you register for that, and if you're already here, you're attending a session, you actually will receive a free case through NextChapter, which is a good segue into our next session. We're going to be hosting a live workshop to go through NextChapter, our bankruptcy software, showing you the ins of the out from setting up your firm to preparing your filing, and really all the tools that you would need to get started right away. We're going to be doing that in our next session. So if you're not registered, please do so. And again, we have the links all in the chat on the side. And we're also going to send the slide deck here that Josh shared to all of the session attendees, as well as a recording too. So if you want to come back to any of this awesome information, you're going to have it available via email by the end of the day today. Yeah, so thank you all. Thank you again, Josh, for sharing. I hope that everyone found this all very insightful. I think it was amazing information and a good setup for diving in on the next sessions here to come. So thank you, everyone, and hope to see you all in the next sessions.